Thank you very much, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Madam Speaker, I consider myself very privileged to rise today to speak to this bill, an act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011. And I say that because we have long been in the making of our attempts on the part of this government to make a fundamental and critical improvement of the criminal justice system of this country. And this bill, before this Parliament today, is a significant step in that regard in reducing the endemic delay in the criminal trial process. Madam Speaker, the statistics demonstrate that as at March 2023, there are approximately 37,933 pending indictable matters at the district courts. That means that there are 37,933 criminal offenses, including murders, attempted murders, robberies, rapes, trafficking in persons, misbehavior in public office, and other types of fraud that are currently pending at the pre-trial stage. Madam Speaker, these numbers do not merely represent pending matters or charges. They represent thousands of persons whose lives have been disrupted and who wait anxiously for some form of progress and/or closure in respect of a criminal trial which has followed them like a shadow for many years. It must be emphasized that every one of these 37,933 matters, there are accused persons, sometimes multiple accused persons, a victim, sometimes multiple victims, tens of witnesses and distressed family members, and of course, the members of the wider public. This is the reality of our criminal justice pre-trial system. To add to this number is the average of 8,835 indictable offenses filed annually, which now joins the queue of the 37,933 pending matters. Critically, Madam Speaker, it is well known that the work of conducting preliminary inquiries is shared between the Office of the Director of Public Prosecutions and the Trinidad and Tobago Police Service. We have received information from the Office of the DPP. State counsel of this office are tasked with the conduct of the most serious, most high-profile matters, the preliminary inquiries of highest public interest, among, of course, other work to that which they are also committed. At current, the Office of the Director of Public Prosecutions has under its conduct approximately 2,120 preliminary inquiries. For the period 2013 to 2023, the Office of the DPP has concluded 900 preliminary inquiries. Madam Speaker, while that figure has not been disaggregated per annum, it does round off to an average of approximately 90 preliminary inquiries per annum being completed by the Office of the Director of Public Prosecutions. Statistics received from the Trinidad and Tobago Police Service for the period 2013 to 2023 demonstrate the astronomical number of preliminary inquiries currently engaged in the police service, which averages between 4,000 to 6,000 annually, with a grand total of 55,037 for the past decade. Further, there is currently an alarming backlog of 11,707 preliminary inquiries engaging the attention of the Trinidad and Tobago Police Service. These statistics alone demonstrate the critical need to immediately pass this bill to remove this protracted preliminary inquiry process from our criminal justice system, which clearly overburdens our law enforcement resources. In looking at the statistics, with an overall average of 37,933 pending matters and an approximate additional 8,835 joining the list every year, it is clear that the pre-trial phase of the criminal justice system is in dire need of improvement. I repeat, the pre-trial phase. And by that I refer to the preliminary inquiry process phase, because the reality of our criminal justice system under the existing law, which this bill is seeking to make significant improvements to, is that for every criminal charge that is faced by an accused person, that person has to go through 2 trials. The preliminary inquiry trial, and then if there is an indictment, the actual trial of the indictment before the High Court. Madam Speaker, this is not the first legislative attempt of this government to abolish preliminary inquiries. I could list them out in large detail, but I would not belabor the time that is available to me to do that, because I am here not so much concerned with belaboring the history of the endemic need to improve the criminal justice system, as I am here to persuade this House to move into the future and to join with this government to improve the criminal justice system. Madam Speaker, the harsh reality is that when we introduced paper committals as far back as 2005, we had hoped that those paper committals would have speeded up the pretrial committal process. But what we have instead found is that those paper committals have become a trial before the trial, with requests for numerous witnesses to provide additional oral evidence, full cross-examination, and multiple adjournments. In today's criminal justice system in Trinidad and Tobago, the present system has resulted in countless deficiencies in the system. Inordinate delay in the disposition of preliminary inquiries. Approximately 88% of preliminary inquiries into capital matters taking over 2 years to completion before the indictment can get to the trial stage. And this is modest. In conjunction with that type of delay, it has led to the undue incarceration of accused persons, some of whom are to find out after a delay of several years that a prima facie case has not been made out against them. It has led to the obvious depletion in the quality of evidence, both at the preliminary inquiry stage and any subsequent trial, to the failing memory of eyewitnesses, and to the increase in the number of witnesses who have passed away or cannot be located to provide testimony and subject themselves to cross-examination in order for the evidence fairly to be tested. The impact of prolix cross-examination and the lengthy conduct of preliminary inquiries is another one of the deficiencies plaguing the current system of preliminary inquiries. As well, Madam Speaker, we have a very small criminal defense bar. Once a defense attorney is locked into a preliminary inquiry, the sheer length of those matters tends to deplete the accessibility and availability of defense counsel to adequately represent other accused persons. This government has attempted to do the best that it can by introducing the public defenders as part of our legal aid system, and that has made some measure of difference in improving access to justice. But we need to do more, Madam Speaker. And therefore, we must continue on improving our criminal justice system. We acknowledge there is no constitutional right to a speedy trial. And similarly, we acknowledge, with the benefit of decisions out of the Privy Council, that the preliminary inquiry process is not a process that is protected under the Constitution. We've had the decision of Hilroy Humphreys and the Attorney General of Antigua and Barbuda as far back as 2008, UKPC, in which the Privy Council has made it clear beyond a shadow of doubt that there is nothing unconstitutional in abolishing the lengthy, delaying process of preliminary inquiries. At paragraph 4 of that judgment, The Privy Council said defendants in criminal proceedings do not have a vested right to any particular procedure, and there will generally be nothing unfair in applying whatever procedure is in force when the case comes to court. Madam Speaker, the bill before this House has benefited from the hard work of the officers of the Ministry of the Attorney General and Legal Affairs before my time, under the work of my predecessor in office, and since I have taken office. And I pay tribute to the very hard work of the members of the Legislative Drafting Department, the Law Reform Commission, and the members of the Criminal Justice Unit of the Ministry of the Attorney General. We have had several different pieces of legislation over the year. Act number 3 of 2019, the Administration of Justice Indictable Proceedings Amendment Act 2019. Act number 11 of 2019, the Administration of Justice Indictable Proceedings Amendment number 2 Act 2019. Act number 1 of 2020, the Administration of Justice Indictable Proceedings Amendment Act 2020, and Act number 13 of 2020, the Interception of Communications Amendment Act 2020. Act number 20 of 2020, the Miscellaneous Amendments number 2 Act 2020. All of these being efforts that have been undertaken by this government through the legislative reform process to improve the criminal justice pre-trial phase so as to produce a fast-track criminal trial process that will allow accused persons and affected members of the society, the victims and their families, to ensure that their trials are accomplished in the shortest possible time. And that is why we are here today, Madam Speaker. We are here today after a process of consultation which has been engaged in with the Trinidad and Tobago Police Service, the Director of Public Prosecutions, the Judiciary of Trinidad and Tobago, the Legal Aid and Advisory Authority, in particular, the Public Defender's Department of the Authority, the Law Association of Trinidad and Tobago, the Trinidad and Tobago Prison Service. We are here as a result of the hard work, Madam Speaker, bearing in mind the reconstitution of the Criminal Justice Committee in April 2021, chaired by the Honourable Chief Justice. That committee is comprised of, among other heads of departments, the Attorney General, the Chief Magistrate, the President of the Law Association, the Commissioners of Police and Prisons, the Chief Public Defender, and the Director of Public Prosecutions. The overall aim of that Criminal Justice Committee, which has been working, in particular, among others, on the improvements to this bill, is to tackle the various issues plaguing the key criminal justice stakeholders with the aim of expeditious resolution and cross-agency collaboration. Madam Speaker, the readiness of stakeholders for the abolition of preliminary inquiries has been canvassed throughout the course of the meetings of that committee, and over the last 2 years, the committee has met on a number of occasions to discuss the operationalization of this fast-track legislation. I will then therefore turn, Madam Speaker, if I may, because it is a lengthy bill, to the clauses of the bill that is before this House today. Clause 1 is simply the short title of the proposed act. Clause 2 is the proclamation clause and will provide for the commencement of the proposed act on a date to be fixed by the President. Clause 3 of the bill clearly defines the act to mean the Administration of Justice Indictable Proceedings Act 2011. And I pause there, Madam Speaker, to acknowledge a very intuitive and very telling contribution which was made by a member of the lay public in a conversation that I had with him less than 2 months ago when I was speaking to the fact that the government was seeking to pass this legislation. And I referred to it by its long title, and I said I will call it by its short title, AJIPA. And that member of the lay public said to me, Mr. Attorney General, you lawyers like to talk in lawyers' language. What is the name that you can give to this piece of legislation so that the members of the listening public will understand the object of this legislation? So the name, in deference to that very intelligent gentleman, the name that I give to the bill that is before this House this afternoon is the Fast Track Trial Law. The Fast Track Trial Law is intended, Madam President, Madam Speaker, I beg your pardon, when we pass it in due course, to expedite the process of criminal trials, to move us from the current reality that we now exist in, where on average it takes 2 to 3 years to finish a preliminary inquiry while the accused are incarcerated in jail. In some instances, and I will not go into that, we know of preliminary inquiries that have not yet been completed and are in train for 15 years. That is why this legislation that I bring before this House this afternoon, I will refer to as the Fast Track Trial Law, because we want to give people their entitlement according to justice to be tried in a speedy, efficient, and fair manner as is possible, to bring relief to them, they who are accused of crimes, and to those who are affected by the crimes, the victims and the families of the victims and the members of the public of this country. Clause 4 of the bill, Madam Speaker, importantly inserts definitions in, among other definitions, and one or two of them are worth discussing. The term appropriate adult is introduced because appropriate adult, when you read it in relation to the different legislation that this fast track law has to be read with, involves children and persons who fall within the brackets of age groups who will be referred to as appropriate adults who are charged with certain crimes. But we want to bring those trials to the earliest possible conclusion. Another definition that is introduced by this legislation is the enhanced definition of prosecutor through a consequential amendment that is going to be made to the Police Service Act, specifically by inserting Section 64A of the Police Service Act to require that for the purpose of this fast-track trial law, police prosecutors must comply with the requirements of the Legal Profession Act so that police prosecutors who are trained to practice law can appear before a master of the High Court and conduct pretrial hearings. The reason for this expansion of the definition of prosecutor, Madam Speaker, at the pretrial hearing stage is to allow police prosecutors who are legally qualified to practice to augment the efforts of state counsel employed with the Office of the Director of Public Prosecutions. Clause 5, Madam Speaker. Clause 5 of the bill addresses the issues of part-heard preliminary inquiries and what occurs with those matters when the fast-track trial law is proclaimed. The point there being that when this act is proclaimed, there will still be existing matters that are on the file. And therefore, what are the circumstances in which the master will determine whether those matters remain at the summary level to be completed before the magistrates, or whether the master can direct that the matters be brought into the High Court to comply with the provisions of the fast-track trial law in order to give the accused and the victims an opportunity for expedited justice. And the amendments that are introduced by Clause 5 of the bill are intended to give to the Master of the High Court the discretion to make the choice between those matters which remain in the summary trial phase or those matters that come into the fast-track trial phase. Clause 6 of the bill will require a report to be filed in the High Court within 14 days by a constable upon the execution of a search warrant, and this acts as a necessary check and balance. It is part of the wider purport of the section which has been amended. Clause 7 of the bill, Madam Speaker, will allow for sections 13(2) to 4 and section 14 of the Interception of Communications Act to apply where a search warrant has been issued under the fast-track trial law for the purposes of obtaining data. This allows for enhanced cooperation with providers and law enforcement for the purposes of this new law that we are bringing into effect, Subsection 1A specifying that Section 1 will apply to a search warrant issued by a master or issued by a person who exercises concurrent jurisdiction with a master under Section 10 of the Act, that is to say, the Registrar of the Supreme Court. Clause 8 of the bill, Madam Speaker, will amend Section 6 of the Act by repealing subsections 1, 1A, and 1B and substituting new sections, detailing a procedure as it relates to the instituting of indictable proceedings and compelling the appearance of the accused. The clause will amend Section 6 by inserting a new subsection 1D, that deals with a complaint where the accused is a child or where there is a children charged matter within the meaning of Section 3 of the Family and Children Division Act. Clause 8 also inserts a new subsection 2A to provide for the circumstance in which a complaint is not made, but an indictment is preferred and filed under subsection 6.2, which is known as a voluntary bill of indictment. This allows the master to issue a warrant of apprehension to compel the accused's presence before a master for an initial hearing. This bill proposes that the accused will be subject to a sufficiency hearing, even in circumstances where the Director of Public Prosecutions files a voluntary bill of indictment. The rationale there being, Madam Speaker, to produce balance, to ensure that even while the bill preserves the independent remit and all of the powers of the Director of Public Prosecutions under the Constitution, the sufficiency of the evidence that comes before the master can still remain to be judicially assessed. So if at that stage the master is of the view that an insufficient case has been made out, the master can deal with the evidence at that initial stage in the interest of justice. And Madam Speaker, under Section 23 of the current Preliminary Inquiry Act, the power of the DPP to prefer an indictment or not has been conducted under certain circumstances. That has been addressed in the amendments that are being brought to this House by this bill. Madam Speaker, Clause 8 will also amend Section 6.3 by deleting paragraph E and substituting new paragraphs E to H. These new paragraphs will allow the Director of Public Prosecutions to prefer and file an indictment under subsection 2 where a preliminary inquiry or sufficiency hearing is not completed and the offense is of a violent or sexual nature involving trafficking of persons, where the accused or witness is a child or an adult witness is murdered or subjected to violence, or where the witness or victim is not resident in Trinidad and Tobago. Clauses 9 and 10 of the bill, Madam Speaker, insert the new Section 6A, allowing for a notice of complaint to be given to the Director of Public Prosecutions by the Master of the High Court where a complaint is made under Section 6.1. This notice is necessary to alert the Director of Public Prosecutions to any private indictable offenses which have been filed. Clause 10 of the bill will amend Section 7 by repealing the old subsection 7, which speaks to a master issuing a summons directly to an accused who is likely to leave the country to appear forthwith. And that is then addressed at Clause 11, Madam Speaker, which amends the marginal note to Section 8 by deleting the words apprehension of the accused and substituting the words arrest warrant. It inserts a new subsection 1A, which allows a master, if he or she thinks fit, to issue a warrant in cases where the accused is likely to leave Trinidad and Tobago. The practical need for this is patent, and I need say no more on that. This clause, Madam Speaker, will amend Section 8.6 by deleting the words or where this is not possible, a magistrate, and will also repeal Section 8.7 and substitute it with a new Section 8.7, which will permit a police officer to bring a person who is arrested and charged with an indictable offense before a master forthwith, or the earliest available court date after the person is charged. This clause also deletes the words or magistrate in subsection 8, because you would appreciate, Madam Speaker, we are seeking by this bill to move indictable matters at the pre-trial stage out of the jurisdiction, the summary jurisdiction before the masters, and move them all into the High Court in these two stages, the initial hearing stage and the sufficiency hearing stage. Madam Speaker, Clause 12 of the bill will repeal Section 8A of the Act because the appearance, as I just explained, of the accused at the Magistrates' Court is no longer contemplated, since under this fast-track trial law, all indictable matters, subject of course to certain exceptions, commence in the High Court. An accused charged with an indictable matter should not have to appear before a magistrate in the district courts unless his matter is triable either way and is being dealt with summarily. It bears emphasis, Madam Speaker, that this fast-track law envisions a transformative change to our pre-trial procedure. Once your matter, your charge, is laid at the Supreme Court, a straightforward trial assessment and process follows through to finality of trial in one place, that is to say, the High Court, in a timely manner. Clause 13 of the bill, Madam Speaker, will amend Section 10 of the Act by deleting the words of masters and magistrates for the same reason in the marginal note, and in subsection 1 by deleting the words magistrate or magistracy registrars and clerk of the clause. Clerk of the court, I beg your pardon. The clause will insert a new subsection 1A to ensure that magistrates, magistracy registrars, and clerks of the court will not exercise jurisdiction in relation to any matter referred to in subsection 1 or for which a master is given jurisdiction under this Act. In order to harmonize the Act in accordance with Section 10, 1A, subsections 2, 2A, 3, and 4 will also be amended by removing the words magistrate or magistracy registrar and clerk of the court wherever they appear. This fast-track law, Madam Speaker, aims not only to streamline the process, but also to streamline the role of judicial officers by reducing duality of function. No longer are we going to have two trials for the same charge, one at the preliminary inquiry stage before a master and the other before the High Court on indictment. No longer. Clause 14 of the bill, Madam President, will amend the Act by inserting after Section 10 a new Section 10A which addresses the jurisdiction of the Children's Court. And you will see cross-referencing throughout this bill to allow for the operation of the jurisdiction of masters and judges of the High Court to provide clarity on when the jurisdiction of the Children's Court will apply. The initial hearing stage of the criminal pretrial process, Madam Speaker, is dealt with from clauses 15 to 19. And as I had said at the beginning, those stages can be prosecuted both by police prosecutors, legally trained, as well as officers of the Office of the Director of Public Prosecutions. Clause 15 of the bill will amend Section 11 of the Act dealing with the initial hearing relative to issues addressed by the scheduling order. And it is perhaps worth spending just a little time to say what the scheduling order, Madam Speaker, deals with at that initial stage. When a scheduling order is being dealt with at that initial stage, if you will permit me to refer to Clause 11. I read from Clause 11, Section 11, subsection 2 of the Act as it will be amended. Subject to the rules at an initial hearing, a master shall, where practicable, do a number of things. And among the things that the master will do at that initial hearing, which must be dealt with in the first 3 months of the indictment being laid at the initial hearing, the master may make a scheduling order in a form that is set out, dealing with, among other things, that the accused shall, if applicable, retain an attorney at law, an order for legal aid shall, if applicable, be satisfied, the police shall submit to the Director of Public Prosecutions the complaint, any account given by the accused in an interview or statement, any written statement of a witness or document exhibit, a list of exhibits, the accused's criminal record, any available statement of the effect of the offense on a victim's family, or any other persons. The prosecutor shall file in the High Court and serve on the accused the indictment and all witness statements and other documentary evidence that he intends to use at the sufficiency hearing, which date shall be no later than 3 months from the making of the schedule in order, or such longer period as the master thinks fit. The accused shall file in the High Court and serve on the prosecutor any witness statements and other documentary evidence that he intends to use at the sufficiency hearing, which date shall be no later than 28 days from the date specified above, or such longer period as the master thinks fit in his or her discretion. And the sufficiency hearing shall commence, which date shall be no later than 28 days, or such longer period as the master thinks fit from the date earlier specified. And then other aspects of the schedule in order are spelled out. The point there being, may it please you, Madam Speaker, that the entire preliminary inquiry stage, as I said earlier, is being divided into those 2 stages of the initial hearing and the sufficiency hearing, all designed to expedite the right of the accused and the right of victims of the family to a fair trial within the shortest possible time. I cannot stress too much the importance of the abolition of the preliminary inquiry for the purpose of expedition in the criminal justice system. The filing of the indictment at the initial hearing stage is an initial step in ensuring that the pretrial proceedings are conducted with greater efficiency than what currently obtains in the preliminary inquiry system. Effectively, once a person is charged, they can be assured that once there is sufficient evidence, their matter will progress through the system as efficiently and smoothly as possible. Notably, this of course does not interfere with the Director of Public Prosecution's ability to amend, add, or withdraw counts on the indictment as is necessary in the discretion of the Director of Public Prosecutions. Clause 16 of the bill, Madam Speaker, will amend the Act by repealing sections 12(1) and 5 and substituting new sections 12(1) to 4 to adjust the manner in which a summary trial of an either-way offense is dealt with under the Act. Madam Speaker, Clause 17 of the bill will amend Section 13 of the Act by repealing subsections 1 and 2 of Section 13 and substituting new subsections in order to provide adequately with respect to the notice of alibi. Clause 18 of the bill will amend Section 14 of the Act in Section 4 by repealing and substituting a new subsection in order to improve on the clarity of the section addressing the time for tendering alibi evidence. Clause 19 of the bill will amend Section 17(5) of the Act by deleting the words "by reason of illness or accident" and substituting the words because of illness, accident, or any other reason, in order to extend the situations under which a master is able to order the further remand of an accused due to his absence at the adjournment under Section 16 for a period of no longer than 28 days. The sufficiency herein, Madam Speaker, is provided for at clauses 20 through to 37 of the bill before this House. Importantly, clauses 20 to 37 of the bill will deal with the sufficiency hearing after the initial hearing stage has taken it to the sufficiency hearing by way of the schedule in order. Clause 20 of the bill will amend Section 19 of the Act by repealing certain subsections 1, 2, and 4 and substituting new sections in order to improve the language in relation to the various procedures at a sufficiency hearing. This clause also removes a reference to Section 6, subsection 2 in subsection 1, where the Director of Public Prosecutions would now be subject to a sufficiency hearing, remembering that the master will have a discretion to assess the sufficiency of the evidence even where the indictment has been filed independently by the Director of Public Prosecutions. As mentioned earlier, this bill proposes that the accused will be subject to a sufficiency hearing in those circumstances, with the rationale being to balance to ensure that while the Section 90 powers of the Director of Public Prosecutions are maintained, sufficiency of evidence is still to be judicially assessed. Madam Speaker, this clause will amend Section 19 of the Act by deleting and substituting the chapeau in subsection 4 in order to improve the language and ensure that the procedure is properly explained. This clause will also repeal subsection 6, 7, and 8.
Sorry. Thank you very much, Madam Speaker. Madam Speaker, I beg to move that the House to now adjourn to a date to be fixed.
Honourable members, the question is that the House do now adjourn to a date to be fixed. All in favour say aye. Aye. Any against? The ayes have it. This House now stands adjourned to a date to be fixed.